Welcome once again to Lehto's Law. Here's Steve Lehto.
I've spoken before about how Michigan has a statute on the books called the Michigan Consumer Protection Act, but it's basically become a useless statute because our Supreme Court, in its infinite wisdom, said that the exceptions to the act basically swallow the entire act, so it doesn't really cover anybody. And it's a crazy ruling, but what can you do? So I've pointed out before that most states have parallel statutes. They're often referred to as unfair and deceptive trade practice acts. And different states call them different things. And so one of the interesting things about the statutes is quite often they allow for an individual to sue a merchant that has wronged them. You got ripped off by a merchant, you can sue them. Likewise, they often empower the attorney general or different entities within the state government to pursue bad actors and go after them as well. And quite often the statutes say that you can get your damages back. Some states say you can have the damages doubled or trebled based on whether or not the acts were intentional. And some states also can get your attorney fees paid by the defendant if you win, which makes sense because if you had to pay your own attorney fees, it might not make sense to pursue it otherwise. So great story out of Ohio that Patrick sent me and said, Steve, check this out. From WKBN, Channel 27 out of Columbus, Caitlin Hall wrote it. Judge orders Ohio contractor who deceived customers to shut down his business. A judge is shutting down the business. A longtime home improvement contractor who deceived dozens of his customers and then flouted a judge's injunction has been held in civil contempt and ordered to stop operating his business immediately. And a court injunction is not something you want to ignore. Court orders telling you to do something or not do something, you ought to do them. Otherwise, you get in trouble. In addition, the man and his company must turn over their assets for liquidation and distribution to aggrieved consumers. So the judge has actually said, you stop doing what you're doing, turn over all the assets of the company to the court, and we're going to distribute it to all the people you've hurt. Some people just don't get it, says Ohio Attorney General Dave Yost. He was already under injunction to stop this and just kept going. Now he's in contempt of court, and we're taking away his company and its assets. Case originated in February of last year when the AG's office filed a complaint in the County Common Pleas Court against the man and his company, alleging multiple violations of Ohio's consumer protection laws. The man is the only individual associated with a construction company. So it's one guy operating a one-man operation under the name of a construction company. An investigation by the Attorney General's Consumer Protection Section found that the man and his company would request down payments, then either perform no work, shoddy work, or incomplete work on home improvement projects. The investigation also found the man failed to obtain permits, failed to register as a contractor, wrote unfair and one-sided contracts, and stalled and evaded other legal obligations. These are, as I've mentioned before, my professors would say, traps for the stupid. Because if you don't pull a permit, that is one of the easiest ways to get caught and get in trouble for what you're doing. Now, there are some people, contractors, who would know that you can not pull a permit, for instance, for something that's being done inside of a house, and you might get away with it because building inspectors driving around aren't going to see you working inside a house. Unless they see that truck in the driveway for a couple of days, they might start wondering, but how are they going to get inside the house to find out? But not pulling permits, it's a slam dunk when somebody comes in and goes, oh, all this work got done, but no permit got pulled. And when I said a second ago, how they going to get inside the house, the homeowner's going to let them in when they get mad at you. So you give a guy a down payment, say, do some work in my house. He does shoddy work and he leaves. I call the building inspector, comes out and goes, well, that's weird. Guy never pulled a permit. What's his name? Oh, he's not even technically a contractor. Now, all kinds of bad things will happen to him. So in October of last year, at the request of the Attorney General's office, the judge issued a preliminary injunction against the man and his company and appointed a receiver to take charge of its operations. The judge told the man that if he continued to work, he was to do so only in accordance with the law and with the approval of the receiver. And the man disregarded the order. So a lot of times a business will have a receiver appointed. That's a person who's going to step in and take over the assets and what comes and goes from the company. So the judge tells you, that guy's now your boss. That guy's now your boss. So in accordance with the law we're talking about here is the Consumer Sales Practices Act, the CSPA, the Consumer Sales Practices Act. I glanced at it, and it looks to be very, very similar to Michigan's Consumer Protection Act. In that, you can sue for violations of the law. If they're knowing violations, it escalates the damages. You can get your attorney fees paid under certain circumstances to make it worth your while, and it empowers both private individuals and the government to go after somebody who's violating the CSPA, the Consumer Sales Practices Act of Ohio. Instead, the man began a substantial construction project in January of this year for a Summit County couple without first obtaining permits. In a series of recorded conversations made by the couple, the man made a number of misrepresentations to them. Alarmed, the couple contacted the Attorney General's office, which resulted in the filing of a motion for contempt in February. A motion for contempt. At a hearing spanning several days in March, there's testimony and evidence, including the recorded consumer conversations, established the man was violating Ohio's consumer protection laws in a number of ways. In his civil contempt ruling, the judge noted the man repeatedly made material misrepresentations to his customers, flaunted the authority of the court, and continues to believe that nobody can shut down his company of 45 years. Judge also noted the man failed to turn over all the bank accounts to the receiver as ordered. So several conditions are now there that the man must meet to avoid a fine and jail time, including he must do the following within the next couple weeks: cease all operations. Period. He must return $69,000 to the Summit County couple. He has to turn over to the receiver any outstanding cash and other assets that he holds or his company holds. And he must provide the receiver with information on all bank accounts, bonding, insurance, and titles to any personal property. And if I had to guess, if it's gotten this far, it's going to stay ugly. Meaning that if the guy didn't turn this stuff over before, he might not turn it over now. He might think, oh, I've been in business for 45 years. I know what I'm doing. The receiver will liquidate the assets and set up a claims process for the man's customers. The next act of contempt could be a criminal offense, resulting in a larger fine and more jail time. So that's not good. And I know from my own personal experience, what I've seen in Michigan is that the Attorney General's office going after businesses in situations like this usually only does so after they get a whole bunch of complaints. I was very good friends for a long time with somebody who worked in the Consumer Protection Division of the Michigan Attorney General's office. And I remember being in Lansing in their office and them showing me a wall of cabinets, over 6 feet tall, 10, 15 feet across, one side the other, one end to the other. And she said, these are our active complaints. After we close them, they go someplace else. But this wall of complaints. And I said, so what do you guys do? And basically they're just treading water. They were literally just, they get a complaint in, they glance at it, they do what they could with it. But she said that what got their attention, what put something on their radar, was when they started getting repeated complaints about one entity. Or if it was a large scale problem with respect to how much money was involved. But sadly, there were a bunch of companies out there that were ripping people off for small amounts of money. They were getting away with it. I remember for a while there's a company that sold seeds by mail order in Michigan. Seeds, like, gardening seeds and vegetable seeds and stuff you'd plant in your yard. And apparently they had a very, very deceptive business model because they got so many complaints about, to this day, I can tell you the name of the company. It's over 20 years ago. I heard it one time and I remember, what? How many complaints have you gotten about this one company selling seeds? And she said, what can I tell you? They advertise in the right places. They rip people off. They keep the money. And now they're here. And she goes, we keep trying to deal with them, but they're hard to go after for a variety of reasons, which I won't even go into right now. But when there was an actor, when there's somebody out there doing bad things, and they're doing it repeatedly, especially for a lot of money, that's when the AG's office would come in. And so for a one-person business, building contractor, who's got one employee himself, and if he's gotten on the AG's radar in Ohio, it really makes you wonder. Especially he's been in business for 45 years, And not only did the judge tell him to stop what he's doing, but has shut his business down and is liquidating it. I mean, that's an extreme remedy if you think about it. And I've never heard of that happening, at least not like that in Michigan. I've heard of people who were chased into bankruptcy court. That is, they had so much bad stuff happening that they ran to bankruptcy court for protection. This guy apparently was just liquidated by the court because they said, you know something? He owes so much money to people that that's the only way we can get this money back. So, crazy story. It's good to know that Ohio at least has a good Consumer Sales Practices Act. Michigan doesn't, but Ohio does. Patrick, thanks for sending the story from WKBN Channel 27. Caitlin Hall wrote it, and a judge orders an Ohio contractor who deceived customers to shut down his business completely. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I don't know where I'm going from here, but I promise it won't be boring.